Okay, I was telling you, this is a transcript from a court hearing. Yehuda Ferris of Probate East Bay became the trustee of a cancer patient's trust. But the problem is he didn't give the cancer patient's three siblings their beneficial share of the trust. I mean, he didn't do it. There's no ifs, ands, and buts or excuses or maybes or anything. He never gave them their beneficial share. There were two trusts, and he didn't, even the trust that he recognizes, which is outrageous because it was written when the cancer patient was in a coma, but even that trust that he swears is the real trust, and so does his alleged lawyer, William John Rogers, out of Petaluma, license number 154219, even that trust he didn't honor. That trust said give the three siblings who just lost their brother after 6 years of cancer. Can you imagine the drawn-out emotional trauma? It's like one thing if somebody has cancer and they die in a month and you're shocked, but it's like sudden and quick. But imagine living with 6 years of hearing that your brother has 6 more months to live every 6 months for 6 years. And then when he finally passed away, the rabbi trustee of the Jewish family of senior citizen siblings doesn't give them their beneficial share. Their brother owned half of a $2 million house at 1810 Grant Street, 94703 in Berkeley. And he said, give them $30,000 each, plus 10% interest a year every year they don't get it. And it would be, and if they don't get it in 9 months, it will be in 9 months of his death, it will become a lien on his half of the property until paid in full. And 5 years later, the trustee, supposed to be a rabbi in Berkeley for 45 years, Yehuda Ferris of Chabad Lubavitch, didn't give them anything. They got $4,000 5 years ago for emergency COVID supplies. And now the house is sold out of the property for $82,000. The $85,000 in the bank is gone. And now here's a transcript of a hearing of a little on a lawsuit that one of the siblings filed. So let's get right to it. Okay, it's case number RP22120163, August 19th, 2024. Here you got for respondent Yehuda Ferris. That's rabbi, if he's not a rabbi, but he says Rabbi Yehuda Ferris of Chabad of the East Bay, right? And his attorney, William John Rogers, and then his attorney even has an attorney. You get that? Nathan, who's his attorney? Paul Nathan. Since when does an attorney need an attorney? Yeah, when they're a crook. Sue me for slander, but you got all my money, so if you want to recover any damages, you'd have to sue yourself to get the money. Bunch of thieves. That's right, I said it. Sue me. Okay? So here it says, it's a long transcript, folks, so I'm just going to read from it. It says, index of witnesses, cross-examination by Mr. Horn. Oh, Mr. Horn, oh God, he's another character. He's been a lawyer 5 years. He represents the people who bought the house for $82,000, bought my brother's half of the $2 million house for $80,000. So he's defending these guys as real estate fraudsters. Imagine you'd think that if you're an attorney, you would pick some better clients to start your career. Unless you want to be a criminal defense attorney, but he's supposedly an estate planning attorney. Anyway, so it says here, I'm just going to let the evidence speak for itself. So if you can bear with me here. It says, good morning. Calling the matter of the Lee J. Zipper 2019 trust dated August 2019. This is Judge Sandra Bean. And I think and this is Alameda County Superior Court, Probate Court. And the judge is named Sandra K. Bean. She's the only judge that oversees all the trusts in Alameda County, which is a population of 1.6 million people. I think both parties have petitions, but for these purposes, could the petitioner state their appearance, please? The guy says, yep, okay, that's your name, all right, is here this morning on behalf of the respondents. Mr. Rogers, the attorney he's been an attorney 31 years. He's gotten $57,000 in attorney's fees for the two trusts that he wrote, but the people that are supposed to get money out of the trust got $4,000 5 years ago. and they're elderly Jewish senior citizens. They have no money, no savings, no college education, no degrees, no stock portfolios, no property, and they really needed this money from their late brother. And their late brother really wanted them to get the money. Instead, the shyster attorney got 50. So far, has got 57,000, and the property got sold out of the trust. And it just so happens to be 2 blocks from Yehuda Ferris's latest empty synagogue, and his wife Miriam Ferris, who everybody in the whole Bay Area knows she inherited this enormous real estate empire. She's going around bragging to people, I'm selling that house, I'm selling that house. She even sent me a text message and she said, well, we didn't really sell the house for $82,000, but if we can get you out of there, we're going to put it on the market. But if you go on welfare, you won't be in the street because they'll give you a free house. I mean, I wonder if Bernie Madoff sent text like that. Anyway, it says, good morning, Your Honor. This is the lawyer, Will Rogers, on behalf of the trustee, Rabbi Yehuda Ferris, who is present. Oh, boy. Mr. Horn. Mr. Horn, on behalf of Maxine Ziprin and Flora Ziprin, who are joining remotely. Oh, did I tell you? The cancer patient's own 2 daughters, occupational therapists, working cushy jobs at UCLA and now in Washington. Occupational therapists' average salary is $98,000 a year. So for 6 years, so they knew that their own father had 6 months to live back in 2014. They never spoke to him once. And if you are still with me on page 25, their attorney will state under oath that they never saw their father in 6 years of cancer. And he didn't see him before he died. And in his trust, he says, in both trusts, one that we get part ownership of the property, but I'll tell you about that one, but the one that they came up with, that's 4 months before he died when he was in a coma. I mean, you can't make this stuff up, ladies and gentlemen. It says that the daughters can only get 25% of each of his half. They can't get any more. They can't get 26%, 27%, because it's an irrevocable trust. And so who did Yehuda Ferris sell the property to? The 2 daughters for $80,000. But they didn't see their father in 6 years of cancer. And they don't want to live in the house. They're just being used by the trustee and his wife to transfer the property out of the house so they can fix it up and sell it and take a cut of the profits. I mean, that's the oldest scam in the book. I mean, just anyway. So let's move on to the next. On behalf of the trustee, that's Mr. Horn. He is defending the thieves who stole the young, non-Jewish, Filipino, never converted, anti-Semitic 2 daughters who never saw their father in 6 years, and now they stole the inheritance of his siblings. So he left some of his house to his 3 siblings, and then the trustee sells the property to the 2 daughters for $80,000, but the whole house is worth $2 million. But then doesn't give a penny to the siblings. They got $4,000 for food during COVID, and now the whole trust is empty. And they got the nerve to lie to the court and say, well, we tried to give them $30,000, but they just wouldn't take it. They didn't give nobody 3 cents. This guy, Briar Horn, will be saying, well, see, there was a chance for them to get their whole beneficial share, and they didn't take it. Did they even call anybody? There's not a record of the trustee contacting my 2 sisters even once in 6 years. So how could they reject the settlement if they were never contacted? They were never offered a settlement, and neither was I. This is the pure corruption that goes on in trust and probate fraud, ladies and gentlemen. Okay, so it says, who is present now? And that's Briar Horn. He's a new attorney, and he's got nothing better to do but represent a couple of elder-abusing, anti-Semitic thieves who ran their father into the grave by not seeing him when he was dying of cancer, which could have cured him. He could have gone into remission if he had some love from his own flesh and blood daughters that he raised from birth and worked with his blood, sweat, and tears building houses to pay the mortgage on the house. And then when he gets cancer, they ignore him for 6 years. And then he leaves some of his house to his poor elderly Jewish siblings, and they turn around and steal their inheritance, their beneficial share. How? By breaking the terms of the irrevocable trust, which forbids them to get any more than 25% by buying it for $80,000. But the whole house is worth $2 million. So you give them half of a $2 million house for $82,000, and then they turn around. The Rabbi Yehuda Ferris says, well, we tried to give the three siblings $30,000 each, but they wouldn't take it. They never called the siblings. They never spoke to them. They never offered them anything, but they just lie and lie and lie. That's where we are today. So someday we'll get to the transcript here. Okay, so it says, just giving you a little history. Briar Horn, on behalf of the two daughters that never saw their father, who are joining remotely, and Paul Nathan on behalf of Roger. Why does the attorney for the trustee need an attorney? The judge says, all right. And Mr. Horn, or your clients are parties. It's fine for them to appear remotely. If you're going to be calling them as witnesses, I need a declaration. Yes, those declarations were submitted on Friday. I have copies here. I see nothing on the Register of Actions. They were served on the other parties, and they were submitted to the court on Friday. Were they filed? Yes, submitted for filing electronically, and I have copies here. If you'd like to see them, yeah, I like to see those. I have reviewed the declaration, and the court will accept these declarations and allow them to appear remotely. Okay, thank you. And then the judge says, all right, and so the first issue we need to address is the 16061.7 issue. So the court attempted to review that you referred to Mr. Margulies' estate of Young. That does not exist, whatever that means. The court did not find one case that was on point. The court did find one case that was on point in the form of 16061.7. That is Hurstack versus Wilkins, 84 cap, blah, blah, blah. That appears to be the guiding principle of the court in interpreting this particular statute. And so, Mr. Rogers, then the brother of the cancer patient who got ripped off for his inheritance along with his two elderly sisters, I wasn't finished with my presentation on Friday. The judge, I'm sorry, I wasn't finished with my presentation. I had a lot more material, and you said see you Monday. Okay, did you file something with the court? No, I just have my notes. Okay, to the extent that you're going to be referring to any case law, it's really important that you file with the court ahead of time so that the court can look at it and consider it. It's not only case law, it's statements. If it's argument, that's fine. But Mr. Rogers, all right, but Mr. Rogers, this is your issue, and this is Mr. Horn's issue. They're the lawyers for the crooks. And by the way, Mr. Rogers got $57,000 in attorney's fees, and the beneficiaries, the siblings of the cancer patient, they got $4,000 5 years ago. I mean, bunch of thieves. This is your issue, Rogers. And so Rogers, who got $50,000, he wrote both trusts, but the siblings never got anything. He says, if I may address this case in a broader sense, he's going to complain about how long it's been. Yeah, you stole the money from cancer patients, and you're complaining that you're still in court. I heard it at Nuremberg. May I address the case in a broader sense first? The motion for judgment on the pleadings is Mr. Horn's motion, and I would probably, if you can speak louder, because I can't hear you. The acoustics here are probably not the best for a voice as low as mine. And then the judge says, Madam Court Attendant, does he have assisted listening? Yes, and I have hearing assistant. I just asking you to speak more clearly. It was kind of muffled to me. So Mr. Rogers, who got $57,000 and some complaints with the bar, that's the deep tone of my voice. I don't know if I could change that. Is this any better? Maybe a little slower. Thanks. The judge, all right, that's the court's job. Just let me know if you're unable to hear. It's very difficult to understand you, by the way, so don't take offense, but all you need to do is talk slowly and carefully. So again, this is the other, Horn is the guy that's representing the two thieves. But I have a sense, and I think the attorneys might sense where this case is going. If we have this motion for judgment on the pleadings, the whole matter could take a couple of minutes. See, he stole, everything got ripped off from the siblings, and he's complaining that things are taking too long. But he didn't mind stealing every penny, selling the $1 million worth of real estate for $82,000. That was okay with him. I found $70,000 in cashier's checks in my brother's house. He took all his money out of the bank weeks before he died, and like an idiot, I gave them to the attorney and the trustee and a key to the safety deposit box, which supposedly had $15,000. So they got $85,000. The trust gets $85,000 because of me, and they turn around and take the $85,000, give all the money to the attorney, sell the property for $82,000, and I'm going to court against him, and he's complaining about, oh my God, I've been in court 4 years. Yeah, you should be in jail for 40 years. Yeah, sue me. You'd have to get, I don't have any money. You took it all, so good luck suing me. If we have this motion for judgment on the pleadings, the whole matter could take a couple of minutes. And I think this case, which has been going on now for 4.5 years, oh yeah, the Holocaust took 6. It's very difficult to understand from the outside what that's been like. Oh my God, yeah, we stole the money and now we're still in court 4.5 years. Oh my God, you and your crocodile tears kill me. And I think if we end this case in a 90-second hearing, it's going to be a premature death to this case. I have a statement that I'd like to make. It started off being an opening statement for trial, but then I switched it to it may be being a statement. If we're starting a motion, maybe I could say it at the beginning of the motion. But I think there are things that need to be said for all the parties involved who have endured 4.5 years of this. I swear to God. And I'm afraid I want the court's leeway assistance to allow me to make that without starting the whole trial. So maybe we could start the motion, have the motion, and maybe opening statements without ruling on that motion yet. I think the court has probably read my pleadings. I've tried to be really concise. I'm going to provide a concise statement of 4.5 years, boiled down to 10 minutes. You stole the money. When are you going to give it back? And you're complaining about 4.5 years? Where's our money? We haven't had our money for 4.5 years. And I'd like to find a way to say that, Your Honor. So the judge says, all right, so the court has no issue whatsoever. If you'd like to do an opening statement and then allow the court to consider the motion on the pleadings, there's no problem with that. Okay. All right, so let's talk about the motion for judgment on the pleadings. So when the court ruled on that motion, it appears that there was merit to the motion, but we didn't have sufficient information about when the sibling of the cancer patient received the 160.61 notice and wanted to hear some evidence. So I understand that Rogers' office served the notice, which is why I turned to him this morning because the court does want to hear some evidence in regard to that document and have that document in front of us. Okay, well, having said that, Maxine Flores-Zipperman would like to call William Rogers to the stand. All right. Am I going up there? So that's the lawyer for the thief. Since you have a good seat, why don't you just stay in the seat you're in? But are you hearing him okay? So the sibling says yes. Why don't you stay where you are? And Madam Clerk, do you want to swear Mr. Rogers in? Okay, William Donovan has been fully sworn, testifies as follows. Please be seated and state your name. Mr. Rogers, all right. Haven't been duly sworn. I didn't hear him say to swear to tell the whole truth. All right, Mr. Rogers, you probably haven't testified many times before, but you'll probably question witnesses. If there are any witnesses in the courtroom and other than the parties that testified, they need to either leave the courtroom or log off at this time. Otherwise, you will not be permitted to testify. If you are a party, you can certainly stay. What, Mr. Procedural question. When they are finished, the questioning is done. May I question this time, or is that another time? May you what? Question Rogers. Is that another time, or because I have questions for him? You can question him within the scope of the questions that are asked on direct. Okay. So, is there ever a time in the trial when I'll be able to ask him questions? The judge says again, you can question him about the things he's asked about in direct. You can't ask him about anything else at this time. Mr. Margulies. At this time, okay. So someday, all right. So as I was saying, Mr. Rogers, just listen to the question, make sure you understand it, and if you don't, let the attorney know whoever is asking, and they'll, I'm sure, do their best to clarify. So direct examination by Mr. Horn. So this is the attorney representing the thieves who stole the property from the trust in violation of the irrevocable trust, because the 3 siblings, including me, and my 2 sisters, we're supposed to get a lien on the property with interest until paid in full. That was $90,000 5 years ago. But no, they turned around and sold the property for $80,000. And then they go lie and say, well, we tried to give them $30,000. They didn't take it. They never even called anybody. There's no record of a phone call, an email, nothing. They didn't contact anyone except me 3 years ago. They said, get out of the house in 2 months in the middle of the pandemic, and if you don't, you and your sister's not going to get nothing, and you got to accept this offer. But there wasn't any offer. They called 1,000 times. They said, you want me to leave? Give me my money. And do you have my money? Do you have my sister's money? They didn't even answer the phone. I called them 1,400, I called 1,000 times, left messages, text messages, emails. Nobody answered. And then there's a 30-day notice on the door. And then I called the recorder's office. Oh, who owns the house? Not the trust. They sold it illegally to the two daughters who didn't see their father in 6 years. And here's their attorney. Here's their attorney cross-examining the attorney who sold the property to them. So understand, the attorney for the people who broke the trust and bought the property for $80,000, though it's worth $1 million, and me and my sisters were supposed to get a lien on the property until we got $90,000 plus 10% interest a year. He's representing the two daughters who killed their father by never calling him in 6 years of cancer. Yes, ask any doctor if somebody has terminal cancer and the tumors are eating their body. If their daughters never call them, is that going to make the cancer worse and kill them? Of course. That's like saying, does the sun rise in the east and set in the west? Everybody knows that. Well, everybody knows that if you have terminal cancer, 6 months to live, and your own daughters that you raised from birth don't even call you, let alone bring you some soup, give you a hug, help pay your rent, buy you some food. No, they didn't contribute 1 penny to his care. They didn't even call him in 6 years. So he puts in his trust, they only get 25% only. And then they turn around and give him the whole thing for $80,000, but the whole half is worth $1 million. Instead of putting a lien on the property to pay the man's 3 poor elderly siblings, the trustee turns around and gives the whole property to the rich daughters making $100,000 a year who never saw their own father. And so the attorney representing the daughters is Mr. Horn, and the attorney, Mr. Rogers, is the one who sold them the property, and he's the attorney that got $57,000 in attorney's fees, but the siblings still have gotten nothing. So let's move on. Okay, so direct examination by Mr. Horn, representing the daughters who didn't see their dad, who weren't supposed to get only but a quarter of the property. So the attorney for the daughters says to the attorney for the trustee who sold them the property for $80,000, "Can you please introduce yourself to the court? I'm William Rogers. And William Rogers, are you a licensed attorney?" "Yes, since 1991, I'll bet. And can you please explain to the court your involvement in the administration of the Lee J. Ziprin Trust?" "Yes, I'm an attorney for Rabbi Yehuda Ferris, who is the trustee." "And did you serve notification on trustee on the beneficiaries of the Lee J. Ziprin 2000 Trust?" "I mailed notice of administration." Mr. Horn, Will the record reflect that I'm handing the witness a document marked Exhibit Number 71? "All right, the record will so reflect." Bunch of crooks. "Do you recognize this document?" "I do." "And what is it?" "It's the notification by trustee pursuant to California Probate Code, Section 16061.7. "And is this the correct copy of the document?" "It is." Mr. Horn, Your Honor, I have the document marked Exhibits and admitted into evidence. This is such a circus. Any objection? No. All right, then the notification pursuant to California Probate Code Section blah, 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 marked as blah, 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 is admitted into evidence. Oh, it's a smoking gun. If the glove don't fit, you must acquit. Mr. Rogers, is that your signature on page 2 of the document? It is my signature. This is how crooks get over in court. It is. And can you describe what the second and third pages of the document are? The second page is a proof of service. The third page is entitled My Own Handwriting, Scheduled 1 to Proof of Service. That's proof of service and the address it was mailed to. After you mailed the notification to a sibling, did anything occur that led you to believe that the sibling received the notice? Nothing contrary would lead me to believe that he didn't receive the notice. The notice was not returned in the mail marked undelivered, so I assume it was delivered. Duh. Thank you. It was a notification by the trustee, Exhibit 71. That's the only notification that you served on the trust beneficiaries. At the time was the first notification that I gave. At the time, that was the first notification that I gave. And did any person file any trust contest in the 120 days? Nope. And are you aware of anyone having contested the trust after 120? Yep. And who contested the trust? Noam Ziprin, also known as Noam Margulies. And did you know the approximate date he first contested? I don't, but I know it was very close to 2 years after my calculation of the running of the statute of limitations. While looking